Welcome to Trial Talk, insights from experienced New York trial attorney Michael Joseph.
Hello and welcome to Trial Talk, where we break down New York's most dangerous jobs and the laws meant to protect them. I'm your host, Kevin Rosenquist, and as always, I am joined by attorney Michael Joseph. Michael, welcome back.
Thank you.
So last time we talked about tool accidents on construction sites. We're gonna kind of keep going with this same topic. Talk about falling debris, excavators, trench collapses, things like that. Who's liable? So what are the legal rights of workers that are injured by falling debris on a construction site in New York?
So if you're injured by falling debris on a construction site, you have the right to sue the general contractor and landowner. Why? Because New York has something called Labor Law 240. In general, Labor Law 240 is meant to protect workers from any type of gravity-related accident. That means it includes falling debris, falling materials. Basically, the law requires that the general contractor and landowner implement safety practices and install safety equipment to protect people from falling debris, such as nets, chutes. They're supposed to have safe practices. In other words, you're supposed to put materials down through a chute to make sure it doesn't, they don't just throw it off the roof. When materials are being hoisted, for example, you have to have sufficient strength and tension in the tools that are being used to hoist, such as the chains or the cables, have to be of sufficient strength that the cables don't break and the materials don't come flying down. They have to be properly secured and stabilized so they can be lifted safely without injuring somebody. So if you are hurt on a construction site because of falling debris, call a construction accident lawyer because you definitely have a case.
What all is included in Labor Law 240? You mentioned scaffolding, falling out. What all is included in it? Is it pretty broad?
Labor Law 240 is very broad. It basically requires the contractors and site owners to provide protections against gravity, against any kind of injury that can happen from gravity. If you look at the OSHA stats and the New York Department of Building stats, falls and falling objects hitting people are the two most common types of construction accident injuries that occur. That's why the protection is so broad. So, for example, if you have to work at an elevated location, you have to have a good ladder that can elevate, that can sustain your weight. If you have to do facade work, for example, and you have to install new bricks and new masonry, you have to have a scaffold that can support your weight and the weight of the masonry. You're also entitled to fall protection, which means if you're working at above 4 feet, for example, or you're working over openings or open areas, you have to lean over, you're entitled to have lifelines and harnesses to, even if you do fall, the labor law requires the building owner and general contractor to give you secondary protection of the effect of gravity on you from hitting the ground, not only to rise you up, but also to protect you from falling. So we see this a lot with, for example, bridge workers or other workers that have to work at a height, electricians who are constantly working overhead have to have good ladders. Workers that are doing facade work have to have not just scaffolds, but also harnesses in case they fall from the scaffolds or in case the scaffold fails. It also covers falling objects, like we just talked about. So, for example, if another common thing you see is sometimes materials be picked up by the wind and blown over the side of a floor that's still under construction. It doesn't have walls yet. So the materials themselves have to be secured in such a way that they don't fall off of the floors where they're being constructed. We also have cases where, for example, materials have fallen off of roofs. They've been placed along the edge, like bricks or other tools have been placed along the edge of the roof and they've fallen over. You're supposed to have nets, so that doesn't happen. So Labor Law 240 is incredibly broad. It provides protection to construction workers from almost any kind of gravity-related incident you could think of, even materials that are being hoisted up, for example, if they don't have the adequate hoist to do it, to bring them from one level, heavy materials, say, from one level to the next, and it gets dropped because people are doing it and not a mechanical hoist, that it falls and it hits someone, that person can even sue under Labor Law 240. Mm-hmm. So Labor Law 240 makes the owners and general contractors strictly liable for any gravity-related events where they don't provide adequate tools and safety devices. And even if they do provide one safety device, if that safety device fails and fails to protect the worker under Labor Law 240, the owner and general contractor are absolutely liable. Why? Because the onus is on the owner and GC to provide proper protection from gravity to construction workers on New York construction sites.
What about situations like if someone is struck by something like an excavator or other heavy equipment? Is that also covered under 240?
Usually not. Remember, 240 is really related to gravity, okay?
Okay.
And usually excavators tend to be sideways or lateral motion. Now, if an excavator has a chain and it's lifting platforms and the chain breaks and then it falls, the materials fall and hit somebody, then yes, in that scenario, Labor Law 240 applies. But in general, if excavators are moving things and they're under a load, they swing, and that's not really gravity related. However, there are a number of labor laws or regulations under Labor Law 241.6, which is more of a general codification of the requirements to provide a safe work site and safe practices, which incorporates the New York Industrial Code. So the New York Industrial Code, for example, has certain requirements that require buckets to only be lifted when there's an operator at the helm, or that whenever an operator doesn't have his hands on the actual machines, the power to the motor has to be cut off. In other words, or the safety has to be engaged. One of the most common types of accidents you see with excavators is someone actually tapping a control, getting up to look at the rock, or getting up to look at the hole, tapping the excavator, and all of a sudden, it boom, swings and hits somebody. So one of the regulations specifically to prevent that is that whenever the operator doesn't have his hands physically under control and isn't controlling the machine, they have to have the safety on, which cuts the hydraulics to the machine itself. So it doesn't matter if you hit the controls, nothing's going to happen. Other requirements, for example, are that one of the other big requirements is that the only people that are part of the excavation crew are really allowed to be in the swing radius. So that's meant to prevent accidental contact with people passing by. Another regulation, for example, is people are prevented from, or not allowed, or not supposed to be, riding in a bucket for obvious reasons. So there's a whole bunch of these regulations that are meant to protect people from heavy equipment.
Something I've heard about before is trench accidents, trench collapses, things like that. What exactly are these accidents, and what safety measures should be required to prevent them?
Okay. Well, it's a few different types of trench accidents. Okay, the most common trench accident you'll see is once a trench is dug and it's not properly stabilized, the trench can cave in, especially if you're excavating dirt or even pavement and concrete, for example. That when you undermine the integrity of the structure itself, be it concrete or pavement, and you create a hole, it undermines the integrity, and what's higher up can come in. That's why when you do a trench, it's required to have shoring, which are basically either metal or wood that goes alongside and keeps things from caving in. If you have the proper shoring, a trench isn't going to cave in, and people aren't going to get hurt. And that's one of the big requirements with trenches. The other type of accident you see with people a lot is getting into and out of trenches. So a lot of times, they don't give the guys proper ladders. They expect them to just jump down or climb up the side of the wall. Now, remember, if you're climbing up or down, that also involves an elevation differential. So now Labor Law 240 applies to proper protection for elevations and gravity. So if you don't give the guys an adequate ladder to get up and down from the trench, all of a sudden, and they get hurt, now they've violated Labor Law 240. And the general contractor or owner are responsible for not having provided adequate ladders or means to get in and out of the trench. Because there's obviously this differential in height at the level of the foot of the trench and where the trench begins.
Is it similar to what we talked about last time where you can't sue your boss, worker compensation? Does all that same stuff sort of apply with these types of injuries as well?
So in general, the rule is in New York, if you get workers' compensation or your boss secures coverage, you can't sue your boss. However, the landowners and the general contractors have the responsibility to comply with the New York Industrial Code and to comply with Labor Law 240. So they have the general contractor and the landowners have the non-delegable duties to make sure that trenches are shored, to make sure that excavators, even if they're not standing there watching, they should be. That's what the law says. So if for example, a safety isn't engaged on an excavator and someone gets hit, the owner and general contractor are liable. If the bucket doesn't rest on the ground when it's not in use and someone gets hurt, the owner and general contractor are liable. Now, the one caveat is where you have an employer that doesn't carry workers' compensation insurance and they don't provide benefits, the worker can elect to sue the boss directly. And we have
Okay.
a lot with cases with perhaps undocumented immigrants where the employer just doesn't want to know them after they get hurt, drop them off at the hospital, take off and don't report it to workers' comp, or they just don't carry workers' comp and they treat everybody like quote unquote independent contractors, even though they're really not.
How do you is it difficult for you as the attorney to prove negligence or labor law violations after an accident?
Depends on the evidence you have. Certain kinds of evidence, almost the fact that a ladder broke speaks for itself. The fact that a scaffold collapsed speaks for itself. As long as we can establish that the ladder broke or the ladder collapsed or even if the ladder itself, for example, wasn't the right ladder for the job. If you have to stand on the top foot of the ladder, if you have a 6-foot ladder, you have to stand at the top step of the ladder because you didn't have a tall enough ladder. That's still a Labor Law 240 violation. So
Okay.
if we have pictures of what happened and we have confirming witnesses who can say what happened, usually we can prove these cases.
So if the worst happens and someone dies at a construction site accident, what can families do? Is there a wrongful death claim? What is the path forward in those situations?
Well, the family can sue for any type of violation of the labor law, just like the individual can if they were hurt and injured. There's a couple procedural hurdles. The next of kin, usually the wife or the child of someone, if the person wasn't married, has the right to sue, but they have to actually set up an estate. So before a wrongful death action can be brought, the person wants to be a representative has to actually go to surrogate's court and get appointed as the estate representative for the person that died. If you just bring the name, a lawsuit as the wife of the decedent without setting an estate, it's going to at some point get dismissed. So you really have to go to surrogate's court. You have to do it right. We do this for our clients. You have to have the estate set up so that you can sue and bring a cause of action on behalf of the state. Now, typically, what we do is once the person, usually the spouse, gets named as the estate representative, we then bring the lawsuit on behalf of the estate to try and get compensation for the pain and suffering that the person who died suffered before he died. And then also we bring a cause of action for wrongful death, which means we sue for the damages to the beneficiaries. So we try to recover all the financial benefits that the spouse would have received throughout the life of the construction worker.
Okay, so how do those generally play out? Is that a long process? I mean, I'm guessing that the insurance companies and the construction companies are gonna fight that and try to not have to pay it.
Any wrongful death case is always a long process. It has a lot more
Mm-hmm.
hurdles than the typical lawsuit does, because it actually requires several, we'll say, actions. Okay, first you have to go to surrogate's court and have someone named as the estate representative, which in and of itself requires a petition to the surrogate's court. Then you have to file a lawsuit in the Supreme Court to seek damages for pain and suffering for the decedent, as well as loss of financial and other benefits to the dependents. Then, if you reach a settlement at some point, or even get a judgment after trial, you then have to make a further application to the Supreme Court to either approve the settlement or to approve of the distribution of the assets in the wrongful death action. Why? Because typically what you're doing in a wrongful death action is you're bringing a case on behalf of the people who depended on the person that died. In other words, the dependents. Sometimes there's children involved. A lot of times there are children involved. So the courts are very active and have to be sort of oversee who gets what portion of the settlement. It has to all be judicially approved. So a wrongful death action really requires a number of more steps than a traditional lawsuit does. So I think if your spouse was killed unfortunately in a fatal construction accident, you really want to have an attorney who's does both construction accidents and wrongful death, who's familiar with both the circuit process and what has to be proven in the court itself.
We talked about this briefly in our last episode, but just in case people are just checking in on this one, if someone's injured in an accident, or if someone's seriously injured and the family members are trying to take care of things, what's the first step that they should take?
If they have any relatives or friends that are also on the same job site, I'd say I try and have the relatives or friends take pictures of what happened, how the accident document the conditions that caused the accident before the company can start to try to change the narrative or alter the site. Then you really want to speak to an experienced construction accident lawyer who does wrongful death as soon as possible, because there are statute of limitations. In general, there's a statute of limitation for wrongful death for 2 years. There's a construction accident for pain and suffering statute of limitation for 3 years. If the job site was, for example, a municipal job site where they were working on New York City Transit Authority or Port Authority property, or New York City property, or even a state property, you have to file a notice of claim or a notice of intention to file a claim within 90 days. And if you don't do it, you may lose at least one of the defendants if there's not another general contractor you could sue. So time is really ticking when you should be mourning. Certainly companies are already working against you to try to undermine your ability to bring a lawsuit and provide for your family down the line. So you really want somebody on your side as early as possible, protecting you and fighting for you and fighting for your kids.
Yeah, absolutely. Okay. Well, thank you for joining us today on Trial Talk with Michael Joseph. If you've been injured on the job on a construction site, please visit newyorktriallawyers.org to connect with Michael Joseph and get the information you need. Please share this episode, subscribe, and leave us a review. We would greatly appreciate it. Michael, always good to see you. Thanks so much for all the insight.
Thanks again. Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.